Hello, I'm Judge Kevin Busch, presiding judge in the Family Division in the 16th Circuit, Kane County, Illinois. Today I hope to provide you with a judge's perspective on how to effectively try an allocation of parental responsibilities case, what we used to call a custody trial. While no two cases are truly alike, I believe these three takeaways will lessen your stress and increase your chances for a positive result. So what are they? Plan, prep, and presentation. I told you they were simple. However, in my courtroom, I often see lawyers who forget one, if not all, of these factors. I tried cases for 24 years before becoming a judge, so I know how these cases can sometimes heighten your emotion and lead to highly litigious trials. And while some emotion is necessary for an effective presentation, your presentation and your approach should be much more clinical in nature. By that I mean you should tailor your presentation to the factors set out in the Illinois Marriage and Dissolution of Marriage Act, because these are the factors that the court will be focusing on. In January of this year, our legislature enacted a complete overhaul of the Act. 750 ILCS 5/600 now defines caretaking functions. That is the day-to-day tasks necessary to care for the child. Section 602.5 details the factors the court must consider in determining best interests when allocating parental responsibilities and decision-making. And 602.7 has similar factors for the court to consider when allocating parenting time. So, go through the factors. Create an outline. This is your plan. Avoid getting involved in evidence that just addresses petty issues instead of the specific elements set forth in the Act. Avoid the parade of witnesses, of family and friends. Pick your best few witnesses that nail down each specific element you need to prove. Next, prep your witnesses, and whenever possible, go through your examination with them. Anticipate objections. Explain to them what you are trying to establish with their testimony and why an objection might be made, and how you may have to modify your line of questioning to elicit the information they have to offer. Also, don't forget to prepare them for cross-examination. Witnesses generally fear your opponent. They will usually want to help you and hurt the other side. But a witness with that type of an agenda usually does not lend a very compelling testimony. This is even more important when the witness is your client. Warn your witnesses to keep emotions to a minimum. Remind them, just answer the question asked, and not to feel compelled to explain themselves. Assure your witnesses that the questions are asked a certain way for a reason, and that freelancing will not help the case. Assure them that all they are there to do is to provide a truthful account of their lives and the lives of the child. They are not there to win the case for you, and they should not feel challenged by this process in any way. Now, with your plan and prep completed, your presentation should be relatively easy. At trial, stay true to your plan and your preparation. Present your case in an organized, thoughtful, and professional manner. Remember, this is a bench trial. Theatrics have no impact on the trier of fact. While it might feel good at the time and make for a good post-trial story, or even earn you a pat on the back from your client, it usually just aggravates the trial judge, who is truly only interested in ticking off those factors set out in the Illinois Marriage and Dissolution of Marriage Act. So your presentation must focus on them. Resist the urge to engage in finger pointing, name calling, and what I like to refer to as the blame game. So stick to your plan, go through the factors, keep your client's emotions in check, and save yours for closing argument. Take my advice. Follow this formula, plan, prep, and presentation on your next trial, and I suspect you will be happy with the results. Thank you. Good luck.